Don't quite get psychiatric injury? Well, I'm going to give you the key things that your examiner and lecturer absolutely need you to know because I'm one myself. Psychiatric injury focuses on an injury to the mind as opposed to the body. Under the tort of negligence, we know claimants are allowed to claim for physical injuries, but what when it comes to psychological injuries, what does the court say? Well, generally speaking, it's quite a restrictive approach. However, the law will abide by principles divided up into primary victims and secondary victims. So, what's the difference? A primary victim is the one that is in the zone of physical danger, and according to leading cases such as Page and Smith, they are always allowed to make a claim under the tort of negligence when it comes to a psychiatric injury. Secondary victims, however, have a little bit more harder work to do. According to the case of Alcock, there is a criteria that they have to fulfil before the law will allow them to claim as a secondary victim when it comes to psychiatric injury. Let's go through this criteria together. 1. Close tie of love and affection. When it comes to a secondary victim, the first thing that they have to prove that there was a close tie of love and affection to essentially the primary victim. Now, when we talk about close ties of love and affection, yes, this will include things like parents and children and spouses, but the law has been reluctant to apply this in a more broader sense, and it tends to be dealt with on a case-by-case basis. 2. Did you witness the event with your own unaided senses? This means you can't see something on the TV or hear it on the radio and think this is going to be enough for psychiatric injury. You've got to be able to see it with all your natural senses, eyes, hearing, smell, etc. Thirdly, the proximity to the event or its immediate aftermath. Now, the meaning of this has been really developed over different cases, and I'm going to show some of them on the screen now. But generally speaking, it's got to be fairly soon after the event that you're claiming for that shocking event. Although, as I've already said, according to certain cases, there have been a lot of exceptions made in this within the court system. Finally, was it done by a shocking event? Now again, Lord Ackner has been a real principle in this in deciding what is classed as a shocking event, but have a look at the description below because again, the courts have been more reluctant when it comes to certain types of situations just to ensure that we are not opening up the floodgates and allowing too many cases when it comes to psychiatric injury. It truly has to be proved for a secondary victim before they can make a claim. But what does the law say when it comes to rescuers? Well, generally speaking, we know from certain cases that rescuers are no longer given favourable treatment when it comes to claiming for psychiatric injury, and yes, they will also be subjected to the same criteria. So, learn your Alcock criteria really, really well because this is where students often lose marks and this is the part examiners love to test you on. Good luck.